Nick, you can start recording the meeting.
Yes, you can start. You want me to start or somebody from the trust wants to say something?
Yes, sir. Sir, Rucha and Tanaya will start.
Sure.
Yes.
Shall we?
Yes, Tanaya.
Thank you so much, ma'am. Good evening, everyone. My name is Tanya Gandhi, and I am a Delhi Public School 12th grade student. I am also a campus ambassador at PCGT for the year 2021-22.
And I am Rucha Dali, a 12th grade student of Wazi Kekar College, and I am also a campus ambassador for PCGT for the year 2021 and 2022. Tanaya and I will be your host for the event.
Thank you so much, Rucha. Now let's get started. Public Concern for Governance Trust, or PCGT, started as an initiative to stand against a corrupt system. Two brave citizens, Mr. Dara Gandhi and Dr. R.K. Anand, filed a PIL against corrupt practice in the Bombay High Court. And that is how the idea of vigilant and responsible Indians coming together for the society was born.
Thank you so much, Tanaya, for enlightening us with an overview of the organization.
Most welcome, Richa. Well, you know what, Richa, I had this question in my mind. Usually we keep hearing about civil rights, fundamental duties, constitution and all. It is so confusing. Don't you think so?
Yeah, I keep hearing from my college students, from friends of law school too, about how people have rights as citizens of this country. But I certainly wonder if one has to study these complicated subjects to understand these rights.
Well, I'm sure that that's not the case. All of us are citizens. Shouldn't all of us know our laws? I have seen on television how these ministers and officers take oaths on podiums while holding a book. What is it all about?
Yes, they swear by the constitution to serve our country, but they sure seem to be forgetting their promises the next day.
So true, Rucha. Just imagine if we knew all these things about constitution. So not only we could hold them accountable, but we could also protect ourselves in difficult situations.
Yeah, that is so true, Tanaya. It brings us to tonight's event, ladies and gentlemen. Let me begin by introducing the wonderful organizers of the event. PCGT was founded by Mr. Julio Ribeiro, Dr. R.K. Anand, and late Mr. B.G. Deshmukh to increase public participation and activism towards creating a more transparent and efficient governance system. In order to sensitize and mentor the youth about ethical values, with subsequent emphasis on good governance, PCGT started various programs such as the Youth for Governance, Kuchor, Campus Ambassadors, Safety of Women and Children initiative. We regularly organize dialogues, trainings, workshops, and webinars on issues related to governance.
Thank you so much, Rucha, for such substantial information about the organization. Now, it is my honor and privilege to invite Mr. VP Raja, Chairman of PCGT and the trustee who envisioned this constitution program for us. After obtaining 2 postgraduate degrees in physics from Delhi University and Columbia University, USA, respectively, Mr. Raja joined the administrative service in 1974. While in service, he completed a MA in Rural Development Planning from the University of East Anglia, UK. He further obtained a MPhil in Social Sciences from the Indian Institute of Public Administration, New Delhi. As an IAS officer of the Maharashtra cadre, he has worked in various assignments at the district, state, and center. In recognition of his outstanding contribution to administrative reforms while working as a collector for Satara and as Transport Commissioner Maharashtra, Mr. Raja has awarded the Distinguished Government Administration Award. He retired as the principal advisor to the Department of Atomic Energy in September 2008. Thereafter, he was the chairman of Maharashtra Electricity Regulatory Commission for a period of 5 years. I request sir to enlighten us with your words. Over to you, sir.
Thank you, Tanaya, for your very kind words of introduction. we are all gathered today for a wonderful event, and that is start of an absolutely new initiative, the framework of which came from our young people, Ruchi Bhagat taking the initiative for it, what we have termed as the Constitution Literacy Program. And all our trustees fully supported it, unanimously supported it. I myself, having worked in the governmental system, both with the state government as well as with the government of India, I have been involved with somehow automatically using provisions of the Constitution. And luckily, during my tenure, I'm also able to recall a number of instances where, let us say, I've been able to advise ministers, no, don't go this way. You may get into trouble in courts with this. This is not proper. And also advising them on certain things which can be got done, and certain things, sorry, it simply can't be done. The working of the Constitution has been coming under strain. It has come under strain on a number of occasions. So now, after having seen all that, two questions have come to my mind. One is, after all retirement, obviously one has more time to reflect. And one of the things we realize is that in spite of the fact that the Constitution is over 70 years old, it has not been taken to the people. That is, the majority of the citizens of this country do not have too much idea of what this Constitution is all about. And we feel that some of the objectives of PCGT, like demanding accountability, transparency, can really be done only when people are able to see when compromises are made with the Constitution, when something which ought not to be done is getting done. It's something like the famous statement in philosophy, is truth really manifest? If God appears before you, will you be able to recognize that it is God? That kind of a situation. So this is one reason we said, however small it is, we must start this initiative of taking the Constitution to school students, college students, and also to the larger college population who may not be pursuing law as a subject, whether they are engineers or architects or accountancy people or whoever it may be, liberal arts as well as science. That is one aspect. In my experience, there is also a second issue, which is more complex. Of course, knowing the Constitution is the first issue. The second issue is, even after knowing everything, will people abide by the Constitution? I'm only reminded, I think when Mr. Atal Bihari Vajpayee was the Prime Minister of India, a commission was appointed, if I recall, under Justice Venkatachalaya, to review the working of the Constitution, to see how the Constitution is functioning, and to make recommendations accordingly, which he did. But I do recall a few weeks after this commission, appointment of such a commission was announced by the then Honorable Prime Minister, Mr. Atal Bihari Vajpayee, Mr. K.R. Narayanan, who happened to be the President of India at that time, in a completely different function, somewhere made a statement, and the statement was, it is not the Constitution which has let down India. It is the people who run the Constitution who have let down the Constitution. And this statement made by K.R. Narayanan at that time, many, many years ago, appears to be so true even today. That having a constitution, letting everybody know about it is absolutely necessary. It is necessary but not sufficient. There is something else that is required to ensure accountability, to ensure that people who take oath to the constitution understand the solemnity of that oath. And that can be demanded only by citizens. So a larger people, the entire country, citizens knowing the constitution is again the only method of ensuring accountability from the people at various levels who need to operate and work in the day-to-day work within the framework of law as laid down by the constitution. So it is with these noble objectives that we are starting this program, and we are really blessed to have Professor Pithawala give the keynote address for this program, and we hope to learn as we go along and make constant improvements in this achieving this larger goal and vision. Thank you very much. Tanaya, back to you.
Thank you so much, sir. It is so true that it's not the constitution who let down the people, but rather people are the one who certainly let down the constitution. Thank you so much, sir, for your kind words. And thank you so much for highlighting that how constitution is easily misinterpreted and misguided by citizens of this country. Having heard the chairman of PCGT, I would now invite the founding trustee of PCGT, Mr. Julio Ribeiro, sir, to address us. Mr. Julio Ribeiro graduated in Commerce from Southern College and Law from Government Law College. He joined the Indian Police Service in 1953 and rose to be the Commissioner of Police Mumbai from February 1982 to May 1985. Later, he served in quick succession as Director General, Central Reserve Police Force, Director General of Police Gujarat, Special Secretary to the Government of India's Home Ministry, Director General of Police Punjab, and finally the advisor of the Governor of Punjab. Beside other awards, he is the recipient of the Padma Bhushan in 1987. Post-retirement, he was appointed as ambassador to Romania, where he served for 4 years from 1989 to 1993. The then Prime Minister Shri Atal Bihari Vajpayee had asked him to be governor of Jammu and Kashmir, but he declined because of his involvement in social work in his native city of Mumbai. He is the founding trustee of Public Concern for Governance Trust and also heads the Mohalla Ekta Committee, which works for communal harmony. It would be our pleasure to hear from you, sir. Over to you, sir.
Thank you, Tanvi and Tanaya. And I welcome Professor Pithawala from my old college, Government Law College. When I was there, I passed out in 50 with, there was my friend Fali Nariman, whose son is now a judge of the Supreme Court. And he was, Fali is one of the country's leading constitutional lawyers, and he keeps in touch with me. We are old friends. We used to have Professor Tope, who used to lecture us on the Constitution. I remember he was very fond of the book by Dicey, and we knew it almost by heart at that time. So Government Law College has great memories that I have of that college and of the people who were my friends there. One of them was a gentleman called Kamtekar, he was a brilliant student, and he appeared for the competitive exam 1 year ahead of me, and stood second in the whole exam, and then was allotted to the foreign service. I think his last appointment was in Germany. That was his. He was our ambassador to Germany. This is for Professor Pithawalla's. We had our Nani Pithawala, who used to be one of our lecturers, and Justice Chandrachud, who was also, who later became the Chief Justice of India, and whose son, incidentally, also sits on the bench now. Justice Chandrachud was was also teaching us, and I always remember that Justice Chandrachud and Justice Vimadalal, Jal Vimadalal, who became a judge of the Bombay High Court, they used to come very regularly to Pune when I was the superintendent of police there, and their first point of call would be to my office, because they always wanted to touch base with their old pupil. That is what they used to tell me. We have to first touch base with our old pupil. And my whole office used to be quite agog with these two judges of the Bombay High Court. So this is just by the way of memories, because Professor Pithawala is our chief guest today, who is going to inaugurate this particular project of ours, which I think is most essential and useful. And it has taken shape after what is her name? Ruchi Bhagat joined us about 2 or 3 months ago, and Mr. Raja took over as chairman. I think all these ideas are now coming to life, and it is a good thing that PCGT is getting involved in more and more projects that are useful to the people. And as Mr. Raja was telling me, that he teaches the, these various institutions like Bajaj and others who have management courses. And he has 3 such institutions where he goes and lectures. And he asks them, all the three institutions, and the students were studying under him, whether they knew the provisions of the Constitution. And not one student among all those 3 knew that, and they had not even thought about reading the Constitution. Well, you don't have to read the Constitution except if you're a lawyer. But you have to know the main elements of it, the few cardinal points and principles, and that is what we are trying to spread to the schools and colleges here with which we interact throughout the year. We interact with them throughout the year, and it is a good thing that this project has been conceived, and it is going to be taken ahead by Ruchi, and also by Raj Bacha, who has also recently joined us. I think these are 2 young people who are brought a lot of enthusiasm to the old trustees of this of PCGT, and making PCGT more known, and more not only known is not the main reason. It is that more useful to community at large, to the people at large. And our students who are going to be thrown open to this knowledge should be able to themselves spread that, use it for their own purpose, and also for helping others whenever they need help. Because one of the things that PCGT emphasizes is help to others, that every student should be much more less selfish and more selfless. I mean, to help others, particularly those in need. And in our country, there are many, many who need help. And this is where we are trying to establish youth with values, with youth who will become really good leaders of this country, who have the good of the people at heart. So this is the reason why we have this project, and we are very happy that Professor Pithawalla is going to inaugurate it today, and then it will be carried forward by Ruchi and Raj and all the young campus ambassadors and the lead campus ambassadors and the others who are now present and are going to listen to this inaugural address. So thank you so much for giving me a chance to speak on this memorable occasion. Thank you. Tanaya, back to you.
Thank you so much, Pero, sir, for your kind and enlightening words. Your insights and your views always work as guiding force for us as citizens to work upon it. So now I would like to request my colleague Rucha to introduce our honorable speaker.
Thank you, Tanaya. Professor Homer Pithawala was born in August 1946. He obtained his undergraduate degree from St. Xavier's College and then pursued his LLB from Government Law College, Mumbai. Thereafter, he went on to complete his LLM in Business and Constitutional Law from the University of Mumbai. Professor Pithawala dreamed of becoming a lawyer to serve the country since he was a college student, and it motivated him to study law. He decided to pursue his LLM and his preparation for the IAS exam concurrently. Professor Pithawala's diligence paid off since he passed the IAS exam as well as the medicals for it. At that juncture of his life, he was faced with the quandary of joining Mullah and Mullah or going to Missouri for the IAS training. At that point, Mullah and Mullah introduced him to the legal profession, which has seen him assume multifarious roles, from being an advocate to a well-known professor. Professor Pithawala is a practicing advocate at the Supreme Court of India and the Bombay High Court. He is also a solicitor at the Bombay High Court as well as the Supreme Court of England and the Supreme Court of Hong Kong. Professor Pithawala is known for being the senior most professor of law at GLC, Mumbai for the last 48 years. Apart from teaching in India, he has been invited to lecture at the Harvard Law School, the Law School at La Sorbonne, the University of Cambridge, and many others. Many Supreme Court and High Court judges, attorney generals, and ministers have been his students, and he is also well known for his series of textbooks, which aim at imparting legal knowledge in a simple and lucid manner, as well as a series of texts for Indian law students. The royal government of Bhutan invited him to draft the framework of contract law in their country. During his visit, it was discussed in length at a workshop chaired by the Attorney General of Bhutan. This act has now taken effect in Bhutan. Sir, it is our pleasure to hear from you today. Over to you, sir.
Thank you very much. At the outset, I must say that I should first express my gratitude to the public concern for governance trust and the trustees for inviting me today. And I can tell you that it is my honor and privilege, and I am happy to be with all of you today. I am impressed, really impressed by the work which the trust is doing in several areas. But there are two areas where really I must mention that the trust is really doing a very good job. The first is the Youth for Governance, where the trust is trying to spread the knowledge of laws of the Constitution to areas, for example, rural areas where people may not even know that there is something like a Constitution of India. And let us face facts. If I do not know that I have a right, the thought of enforcing that right would never even occur to me. The second area where even I have strong personal views is the trust fight against corruption. Now, when we were students at Government Law College, there was corruption. I'm not saying there was not, but not as rampant as it is today. And we thought that as budding lawyers, we could at least reduce the quantum of corruption, if not abolish it altogether. But I'm sad to say that 55 years later, I find that corruption has actually increased from the lowest level to the topmost level. And I'm not going here on hearsay, but actual experience. I sometimes tell people that unfortunately, corruption is in our blood. And no amount of blood transfusion will help us in this case. I believe that if corruption enters two particular fields, two particular areas, then the country is doomed. These two areas are education and the judiciary. And I am sorry to see that corruption has found its way in both these fields. I do not wish that the day comes when public-spirited people like you will not be able to say that I'm proud to be an Indian. I'm afraid that day is not very far. In fact, some people think the day has already come. I was asked to speak on the Constitution of India. And at the outset, I may tell you that this is one subject which is taught for a full semester, that is 5 to 6 months at the Government Law College. And doing justice to the subject in one evening is really not possible. So what we will do, rather than look at all aspects superficially, what we will do is take certain important aspects and see what they mean and how they work in practice. As you all possibly know, the Constitution is the basic document of a country. Any law which is made, which is inconsistent with the Constitution, will be struck down by the courts as unconstitutional. India has the distinction of having the lengthiest written constitution in the world. I am emphasizing the word written because some of us may not know that it is also possible that there can be an unwritten constitution. And the best example of that is England. There is no written constitution, and yet the rule of law prevails throughout the country. Originally, there were 395 articles in the Constitution. In all other statutes, we use the word section. But as far as the Constitution is concerned, we use the word article. Today, there are more than 500 articles, from 395 to 500 plus. But please don't look at the number of the last article because it still remains 395. The articles which have come in are put between other articles. And sometimes we wonder why our constitution is so lengthy. There are many reasons. The first is that we have taken the best of all existing constitutions at that time. We have taken the structural part of the Constitution from the Government of India Act 1935. The fundamental rights part is based on the Bill of Rights of the American Constitution. The directive principles of state policy have been taken from the Irish Constitution and the cabinet form of government from the unwritten Constitution of England. Detailed provisions are made about the functioning not only of the center, the federal government, but also of the states and their relationships between each other. Provisions are also made for fundamental rights, and we will dwell on that at length a little later, and the directive principles of state policy. Now, I think most of us know that fundamental rights are rights which are conferred and which are enforceable in a court of law. On the other hand, directive principles are just like guiding stars, guiding the government in a particular direction. But apart from these provisions, we also have in our Constitution provisions which I personally feel are not even necessary in the Constitution. For instance, we have provisions relating to panchayats. We have provisions relating to municipalities. We have provisions relating to cooperative societies. All these are governed by other acts, and yet we have them here. We also have provisions relating to the official language, tribal areas, and similar things. Who drafted this constitution? It was the Constituent Assembly under the able leadership of Dr. Ambedkar. Dr. Ambedkar is today regarded as the father of the Indian Constitution. But very few people know that Dr. Ambedkar was also the principal of the Government Law College for 2 years. And as our respected Mr. Ribeiro mentioned, both of us attended the same law school, although of course he was there much before I joined. But we have one thing in common, apart from being alumni of the college. Both of us were taught constitutional law by the same person, Dr. T.K. Tope. Dr. T.K. Tope was really a gigantic personality, and he was an undisputed expert in constitutional law. Now, I said the drafting was done by the Constituent Assembly. But unfortunately, the Assembly itself, the Constituent Assembly itself, was not directly elected. And in one case, the Supreme Court mentioned in Keshavananda Bharati's case that it did not represent a vast majority of the population of India. The very wordings of the judge are, at best, it can be said that it represented 28.5 of the adult population of India. Now, the Constitution opens with a preamble. What is a preamble? It is like an introduction to the main document. The learned author's story says that a preamble is like a key to open the minds of its makers. So it's not a very long preamble. I would like to just read it out. In fact, as students, we used to do this by heart. because it was a sure question in the university exams. The preamble says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote amongst them all fraternity, assuring the dignity of the individual and the unity and integrity of our nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution." So it is we, the people, who have enacted and given to ourselves this Constitution on the 26th November 1949, and it came into effect on 26th January of the next year, 1950. So the four aspects which are emphasized are justice, liberty, equality, and fraternity. These four are what Mr. Pithawalla calls the four pillars of our Constitution. The other important words which are used in the Constitution are sovereign. India is a sovereign country, and it enjoys external as well as internal sovereignty, and it is not subject to any higher superior. Democratic form of government means that the rule of law is prevailing in our country. Now, there were two words which were not there in the original preamble, but which were added in 1976. These two words are socialist and secular. The word socialist is possibly brought in to emphasize the democratic socialism, which aims to end poverty, ignorance, and inequality of opportunity. The word secular emphasizes that there is full freedom of religion, and we already have Articles 25 to 30, which guarantee the freedom of religion. It also implies that there is no state religion in our country, as there is in some other countries. Now, this does not mean that India, as some people say, this does not mean that India is an irreligious country. No. We would rather say that India is a non-religious country. Now, one interesting question is that when the preamble was framed in 1949, would Parliament have the power to amend the preamble? Why? Because the preamble reflects some kind of historical fact. It reflects a momentous time in the history of India. And can any subsequent parliament insert or delete words into the preamble? This question was brought before the Supreme Court, and the Supreme Court said yes, Parliament can do that. This was in the Minerva Mills case. But the noted jurist, Mr. Pithawalla, whom I consider to have been #1 lawyer in the country, he says this is just not possible. How can you amend a historical fact which has already taken place so many years ago? According to him, the preamble is not even capable of being amended. And therefore, his very words are that instead of clarifying the basic structure, the addition of these words makes it dangerously ambiguous. These are his very words. And there is one fact which many people don't know, even I did not know this, that when the Constituent Assembly was debating, the Constitution came into existence, the draft came into existence after extensive debates. And a lot of people expressed their views and everybody respected the views of everybody else. But the little known fact is that somebody had suggested that the word socialist should be put in the preamble. And after full deliberations, the majority of the Constituent Assembly had rejected this proposal. So according to Mr. Pithawalla, the preamble represents a historical fact and no parliament can even think of amending the preamble. Now, as far as amendments are concerned, we have Article 368, which tells us how the Constitution can be amended. It's also very interesting and surprising that the Supreme Court several years ago gave a decision that since the preamble is an introduction to the Constitution, it is not a part of the Constitution. Fortunately, in a later case, the Supreme Court corrected itself and said, no, the preamble is a part of the Constitution. Now, if any provision, Article 368 is the amending article. If any provision of the Constitution is to be amended, it can be done by Parliament by what is known as a special majority. The special majority means that it should be a majority of the total number of members plus 2/3 of the members present and voting. This is the method of amendment. But there are 11 important matters like the election of the President of India, High Courts, Supreme Court, and Article 368 itself, where in addition to the amendment made by Parliament, at least 50% of the states must agree to such amendment. And happily enough, there are certain provisions of the Constitution which cannot be amended. And this is what the Supreme Court laid down, saying that you cannot amend the Constitution to take away the basic features of the Constitution. This was a full bench of all the 13 Supreme Court judges sitting in the Keshavananda Bharati's case. Some examples of things falling under basic structure would be democratic form of government, the federal nature of the Constitution, the secular nature of the Constitution. These are basic features which no parliament can amend. Now, the question sometimes arises as to whether the procedure for amending this Constitution is flexible. Can we call it flexible or can we call it rigid? I think it is not important whether the Constitution is rigid or the Constitution is flexible. It is more important to see the temperament of the people and the parliament. For instance, the Swiss Constitution is regarded as very rigid, but the Swiss people are not. And therefore, this Constitution has been amended several times. The American Constitution is supposed, it's very, very old Constitution, but it has been amended, I think, about 27 times only. And look at the Indian Constitution. it has been amended over 100 times. Sometimes for purely political reasons. And very often, not very often, but sometimes, the amendments have even been struck down by the Supreme Court. The other question which is sometimes asked is whether our constitution is unitary in nature or federal in nature. Now, this is not a very simple question to answer. It's very clear that it's not unitary like the Constitution of England. But does it have all the features of a federal constitution like the American Constitution? A superficial observer will come to the conclusion that yes, there are many provisions which make it federal. But if anybody carefully sees many other provisions of the Constitution, you can come to a conclusion that it is not really as federal as federal should be. Yes, in India, there is what is called List 1 in the Constitution. This is called the Union List. These are very important matters like defense, coins and currency, foreign relations. All these are reserved for the federal government, which means the Lok Sabha and the Rajya Sabha. Then we have List 2, which is the state list. These are local matters like education, police, health, prohibition, museums and libraries, which are left entirely to the state. There is a List 3, which is called the concurrent list. Both Parliament and the state legislature can make laws on items falling within the concurrent list. But if there is any conflict between the federal law and the state law, the federal law will prevail. Now, there could be some matters which have been left out of all the three lists. These would be the residual matters. And it is clearly provided that all residual matters will fall within the competence of the federal government. So here we can see that there is definitely a superiority of the center over the states. To add to this, if a proclamation of emergency is made in the country, then Parliament can legislate on any matter, even if it is in the state list. Similarly, the Rajya Sabha can decide by a 2/3 majority that an item in the state list should be transferred to the concurrent list. Now, what happens when this is done? Anything and everything can be done by the federal government. Because already there is a union list, it is not in the state list, and this has come into the current concurrent list, where again Parliament is supreme. So if at all it is a federal polity, it is one with a very strong center. Also take the case of citizenship. In US, you are a citizen of USA, plus you are a citizen of the state, Texas, California, whatever that is. Here, there is just one single citizenship of the whole country. Mind you, please don't mix the concept of citizenship with the concept of domicile. You may have domicile in Maharashtra, but your citizenship will be of India. Again, as far as the judiciary is concerned, in a federal polity like USA, there are two separate sets of courts. The federal courts will administer the federal laws. The state courts will administer the state laws. But what do we have in India? One set of courts headed by the Supreme Court of India to administer both and interpret both federal laws as well as state laws. What happens when there is a failure of government machinery in a state? The President of India can suspend the state government and Parliament makes laws for that particular state. Another interesting point, only Parliament can create a new state. Now that one can understand. But the Constitution also says that Parliament is empowered to change the boundary of any state. The state has no say in the matter. So Parliament can increase, for example, the boundary of Gujarat and make the state of Maharashtra smaller. We would have no say in the matter. So then what is the conclusion? Definitely it is not a unitary government, but it has several federal features with a strong center. So many people prefer to call India quasi-federal or quasi-federal. But let me tell you that in the case of the declaration of an emergency, it almost becomes a totally unitary state. Then we talk of another very important chapter of the Constitution, which is called Part 3, the part dealing with fundamental rights. Fundamental rights are regarded as the heart of the Constitution. These are basic human rights without which no individual can realize his potential. No individual can live a dignified life. He may exist, but he cannot live a dignified life. Why are these fundamental rights there? Two reasons. One is to control the legislative power of the Parliament. And number two is to control the temporary will of the temporary government, which is in power for a period of 5 years. And Article 13 makes it very clear that even if a law was existing before the Constitution came into force, after the Constitution has come, that law will become invalid to that extent. The wording used is to that extent, which means the entire law does not become invalid, only the one which violates. This is as regards laws which are pre-constitutional laws. What about post-constitutional laws? Laws which are made after the Constitution came into force. If they infringe any fundamental right of the citizen, he can go to the Supreme Court under Article 32. He can go to the High Court under Article 226 and get an order from the court saying that this provision is unconstitutional. Now, what is interesting here is that the right to approach the court is itself a fundamental right. Now, this distinguishes us from other countries where fundamental rights are given, but there is no enforcement. What does one do with paper rights, rights which exist only on paper? Now, there are 11 fundamental rights We may not have the time to go through all of them in detail, but now the number has been reduced to 10. The right to property is no more a fundamental right after 1978. It is also interesting to know, and many of our students do not know this, that some fundamental rights, like 14, Article 14, Article 21, are available to everybody, citizen or non-citizen. But there are some fundamental rights, like Article 19, which are only for citizens of India. The first one, which we take, is equality before the law or equal protection of the law. This article establishes what is called the rule of law in the country. Everybody is equal, whatever is rank, whatever office he may be holding. If I drive past a red traffic signal, I would have to pay a fine. But even if a minister did that, or if a film actor did that, he would be subject to the same. Nobody in the country is above the law. Now, this is very good in theory, but we have to see it with, or rather confronted with, the practical fact of inequality. Everybody is not equal, either in physical capacity, qualifications, or mental capacity. And in fact, if equal treatment was to be given to unequals, that itself would be a violation of the right to equality. For instance, there are many board exams where dyslexic children are given half an hour more to write their papers. Now, to treat such children on a par with a normal child would itself be inequality. And therefore, the American courts came up with the theory of reasonable classification. Although everybody is to be treated equally, the state can make a reasonable classification. And if the classification is reasonable, the courts will not interfere. Mind you, the doctrine of reasonable classification is not spelled out in the Constitution itself. It has been developed by American courts and accepted and adopted by the Indian courts. For instance, if juvenile offenders are tried by one set of courts and other offenders are tried by another set of courts, there is nothing wrong in this. If the law says that if you are riding a motorbike, you must wear a helmet, nobody can argue that why are you differentiating between me and a car driver? Why don't you ask the car driver also to wear a helmet? In Karnataka, there was, or there is possibly now also, a law which exempts Sikhs, Sardarjis, from wearing a helmet on a motorcycle. And the Supreme Court has said that there is nothing wrong in that. What is important is the classification should be reasonable. Who is going to decide that? The court. Also, the classification should have a rational relation to the object for which the classification is made. For example, laws were challenged where there was a separate thing for rulers of Indian states and separate provisions for other persons. The court said this is a valid classification. Separate courts and separate procedures for all suits and separate procedures for suits filed on negotiable instruments. The court said this is a valid classification. Classification into juvenile offenders and other offenders, valid classification. Classification into citizens and non-citizens, valid classification. But when the government tried to classify people into criminals who have a bad reputation, these were the very words used, and other criminals, the court said nonsense. What do you mean by criminals with a bad reputation? Similarly, when one act tried to differentiate between the rich and the poor, the court said this is just not possible. There was an interesting case where a university came up with a rule that there would be a reservation of seats for the employees of that university, for the LLB course. There would be a reservation of seats for the employees of the university and their children. The court said, how can you make this classification? What is the connection between being an employee and doing a course in law? So immediately this was struck down. Then came a law where higher tax was levied on five-star hotels and a lower tax on smaller hotels like dhabas. And the Supreme Court allowed, validated this division. In fact, the Supreme Court, I remember, said that it is very constitutional and very logical to make a difference between a five-star hotel where caviar and champagne is served and a dhaba where some dal, roti and lassi would be served. So this was allowed. Then we have Article 18, which deals with abolition of titles. It says that the state cannot confer any title on anybody except military or academic distinctions. So somebody cannot be made a knight. Somebody cannot be made a lord. Somebody cannot be made a sir. What is the reason for this? Such a thing would create unnecessary distinctions amongst the people. Titles cannot be given, but awards most certainly can be given. Therefore, we have Padma Shri and Padma Bhushan and Bharat Ratna. These are not titles. So when our respected Mr. Ribeiro was conferred the Padma Bhushan in 1987, I think, this was not a violation of Article 8. Then we come to Article 19, which gives only to the citizens of India certain freedoms. And the most important of these freedoms is the freedom of speech and expression. Every citizen has the fullest freedom of speech and expression. But please remember that no right in this world can be unqualified or absolute. And therefore, the Constitution itself says that the state may put reasonable restrictions. The court will decide whether it is reasonable for security of the state, public order, decency, morality, defamation, etc. As I said, no right is absolute. And therefore, I sometimes tell my students that freedom of speech does exist in the Constitution. But please do not exercise this right when you are sitting for an examination. You cannot consult the student next to you and say, oh, but I have the freedom of speech. Use of loudspeakers has also come before the courts. And the man using the loudspeaker says that I have a freedom of using an amplifying device, and therefore it is freedom of speech. And the courts have rightly said that 1 minute, a citizen has a right to hear. Equally, he has a right not to hear. And therefore, if you blast these loudspeakers in the middle of the night, this will not be tolerated. Now, what about freedom of press? Freedom of the press is not mentioned in Article 19. But from the very beginning, all the courts, high courts and the Supreme Court, have unanimously said that it is a part of this freedom. And in a case relating to Times of India, the court said that the government cannot fix the maximum number of pages in the newspaper for a particular price. And in the case of a newspaper called Sakal, the government had ordered the newspaper to reduce its space for advertisements. And the court said, sorry, you cannot do that. This is covered by the freedom of speech and expression. In one interesting case in Kerala, 3 students were expelled from the school. Why? When the national anthem was played, they did not join in because of their religious conviction. But they stood up out of respect. The court cancelled the expulsion, saying that you cannot force the person to sing the national anthem. Now, there are other freedoms which we will go through. In short, there is the freedom to assemble peaceably and without arms, which means you can hold meetings, you can take out processions, but reasonable restrictions can be imposed. Then you have the freedom to form associations, the freedom to move freely throughout India, again subject to reasonable restriction. And therefore, if I am visiting, say, Ladakh, and somebody tells me that you cannot go beyond a particular point, this would be a reasonable restriction. Freedom to reside and settle in any part of India. Freedom to practice any profession, any profession, occupation, trade, or business. The Supreme Court was faced with this interesting point. I think people who are here of my age and older might remember RMDC. This was RMD Chamar Bagwala. And they said that gambling is our business. The Constitution gives us freedom of business, and therefore there should be no interference with our business, so-called business. And of course, the court responded back by saying that crime cannot be a business. Then we have Article 20, which gives a triple protection for offenses. The first protection is given against ex post facto laws. What does this mean? I'll give you a simple example. Today, singing, walking and singing on the pavement is not an offense. So I sing and I walk as I walk on the pavement. Tomorrow, there cannot be a law which says that this is an offense retrospective from last month. Why? Because when I did it, it was not an offense. And therefore, you cannot add a retroactive effect and punish me for something which was perfectly legal when it was done, just because the new law has come. Sometimes punishments are increased. Instead of 1 year jail sentence, Parliament makes it 2 years. Here also the Constitution protects you. When you committed the act, if it was 1 year, there cannot be a retrospective amendment which says that from last month, the jail sentence will be 2 years. So this is protection against ex post facto laws. And this applies mainly to criminal matters. I think we all know about the retrospective taxation laws in the case of Vodafone, which became a very big controversy. Generally, laws should not be retrospective, except if they are procedural laws. Everything is divided into substantive law and procedural law. In the matter of offenses, the Indian Penal Code is the substantive law. The Criminal Procedure Code is the procedural. The second protection is the protection against double jeopardy. No person can be prosecuted and punished for the same crime more than once. So therefore, if a person is acquitted, he cannot again be tried for the same offense. Diverting here for a minute, if you get a chance, do see an American movie called Double Jeopardy. It's an excellent suspense thriller. Okay, I don't want to give you the details because I don't want to spoil the fun when you watch the movie. The third protection given is protection against self-incrimination. No person accused of any offense can be compelled to be a witness against himself. So the accused person cannot be forced to go into the box. He can say, I have nothing to say. And now we come to Article 21, which is protection of life and personal liberty. And I could say that this is the most cherished guarantee in the world. No person, which means citizen or non-citizen, can be deprived of his life or personal liberty except according to the procedure established by law. Mind you, these two words only are used, life and personal liberty. Now, the high courts and the Supreme Courts have enlarged the connotation of these two words thanks to judicial activism. And in Maneka Gandhi's case, for example, the court said that the right to have a passport is part of Article 21. In other cases, the courts have said the right to have a lawyer, the right to legal aid when the man cannot afford a lawyer is a fundamental. Recently, we have seen the Supreme Court saying that the right to privacy is a fundamental right. The right to live with human dignity is a fundamental right. In one interesting case, in Madhya Pradesh, there were open drainage system. And the Supreme Court said that this would interfere and endanger public health. And therefore, Article 21 will not allow this. The right against custodial violence is also recognized as a fundamental right. When there were so many deaths in custody, somebody filed a writ petition. This is the famous case of D.K. Basu. And the court said that you have to follow 11 or 12 guidelines which were laid down by the Supreme Court. And then when we have a very interesting case which involves a very interesting personality, possibly Mr. Ribeiro may be familiar with, I was about to say a gentleman called Charles Shobraj. Charles Shobraj, also famously known, or rather infamously known as the Bikini Killer. He was in jail, and whenever the prisoners were taken to the court for a hearing and then taken back to the jail, they were handcuffed. And Charles Shobraj said that this is a violation of my right to live with dignity. And the Supreme Court agreed. It said, what is the need to handcuff all the prisoners when you bring them to court? Yes, if a prisoner is dangerous, if a prisoner is likely to run away, it is justified. But wearing handcuffs is against the dignity. What if he is a prisoner? Ultimately, he is a human being. I think this is in stark contrast to the American view. And if I have not actually seen it, we have all seen it in movies and television. Every policeman carries a pair of handcuffs. And even in the case of a traffic violation, the cop will push you against the car, put your hands behind you, and handcuff. Then comes the right to education, which was not there in the original constitution. This is 21A, brought into force in 2002. Free and compulsory education is to be given to all children between 6 and 14 years of age in such manner as the state may decide. And pursuant to this, the Right to Education Act was passed. Then we have protection against arrest and detention. Now, there are two kinds of arrest. One is under the ordinary law, where you have possibly committed a crime. And the second is what is called preventive detention. When you are arrested for a crime, this is a kind of a punitive measure. And certain guarantees are given to you. For instance, you should be immediately informed of the grounds of your arrest. You should be allowed to consult a lawyer of your choice, and you should be immediately brought within 24 hours to the nearest magistrate. The time of travel to be excluded. Preventive detention is totally different. This is not punitive. You are saying that this man is likely to commit a crime, and therefore let us arrest him before he commits that crime. Provisions are made for that an advisory board is to be set up. He can be kept in prison only for a particular time. If you want to extend the time, the advisory board must extend this time, etc., etc. Now, what is very interesting about this is that perhaps India is the only country where preventive detention is allowed in normal times. Other countries like US, UK, even Japan, and interestingly, we have one attendee attending this session who is attending from Japan. But in all these countries, preventive detention is only during emergencies. And when the Supreme Court was considering this article, the judge called it a sinister looking feature of the Constitution. Then you have the right against exploitation, which is mainly aimed at preventing traffic in human beings and forced labor. You also have freedom of religion, where every person is free to practice and profess any religion of his choice. Once again, in the loudspeaker case, the court said that I'm sure that the Quran does not prescribe that the namaz should be done via loudspeaker. Constitution also provides that there can be no tax for the promotion of a particular religion. Then you have the cultural and educational rights for the protection of minorities. And then comes the next one, which is Article 32. Article 32 says that the right to approach the Supreme Court for enforcing your fundamental rights is itself a fundamental right. And Dr. Ambedkar once made this statement that if I were to select one article, which is the most important article in the Indian Constitution, I would select Article 32. There is a very famous Latin saying which says, ubi jus, ibi remedium. Wherever there is a right, there has to be a remedy. What is the use of having a right which is a paper right, which you cannot enforce in a court of law? So a right without a remedy really is no right. In fact, I remember reading one English author who very correctly said that we can reverse this maxim and say that if there is no remedy, you can almost be sure that there must be no right. Now, under 32, the Supreme Court has the power to issue what is known, in England it is known as the high prerogative writs. And under Article 226, the high courts can also issue similar writs. This is exactly what happens when somebody says, I'm going to file a writ petition. If you are going to the High Court, it will be 226. If you are going to the Supreme Court, this would be Article 32. But since 226 is a number which is very far away from 32, it does not fall within the chapter on fundamental rights. So your right to approach the Supreme Court is a fundamental, but your right to approach the High Court is not a fundamental. Nevertheless, it is a constitutional right because it is in the Constitution. So 5 specific rights have been mentioned. and the court can pass an order covering these 5 writs or any other writ. The first and the most important is called habeas corpus. In Latin, this means let us have the body, let us see the body. And this is a very, very effective right in all cases of illegal detention. The court says that if you have detained this person, bring that person before me. I will decide whether his detention is legal or illegal. So this is really a very speedy remedy. And either that man himself can apply, or even a relative or a friend can apply. All formalities, all legal formalities regarding going to court are done away with. So when one prisoner sent a telegram to a judge, that telegram was considered to be a writ petition. Then a prisoner in Tihar jail wrote a letter to the court. That letter was considered to be a writ petition. Now, one thing here is that the object of this is remedial and not punitive. So when a man was released from custody and he filed a petition saying that I was ill-treated whilst I was in prison, his petition was dismissed. This is not to punish anybody, but to get you out of illegal detention. But if you are already out, you cannot file this. Now in 1976, there was a very important judgment delivered by the Supreme Court in what is known as the habeas corpus case. And many people feel that although the judiciary in India is very respected, very powerful, and very independent, this particular case was really a blot on the Indian judiciary. What happened in that case was emergency was declared by Mrs. Gandhi. Article 21 was suspended. This is the article which gives you protection against life and personal liberty. All opposition leaders, or most of them, were arrested. Most of them at night from their residences. And when writ petitions were filed all over the country, the Supreme Court said, let us consolidate all these petitions and we'll hear the petition. The government argued that when there is no Article 21, how can you file a writ petition? When your right to life and personal liberty is suspended, how is it possible that you enforce a right which does not exist? 5 judges sat on the bench to decide this case. 4 of them said the government was right. The lone dissenting voice came from a judge, and I'll tell you what happened to that judge a little later. And this was Justice Khanna. Justice Khanna said, how can any authority take away your right to life and liberty? Even if Article 21 was not in the Constitution, you still have this because you are a human being and that is a basic human right. All other judges, including Justice Chandrachud, whom Mr. Ribeiro mentioned, were in the majority and they sided with the government, including Justice Bhagwati, who was later regarded as the champion of fundamental rights. Justice Khanna gave a very, very strong dissenting judgment. All over the world, the majority judgment was criticized. The New York Times went to the extent of saying that India should put up a statue of Justice Khanna for his bold approach. But unfortunately, Justice Khanna had to pay a price. He was the senior most judge who would have naturally become the next Chief Justice of India. When he wrote this dissenting judgment, he went home and he told his sister, "Don't expect me to become the next Chief Justice of India." And he was right. When the time came, he was superseded. A judge who was junior to him was made the Chief Justice of India, and Mr. Justice Khanna resigned in frustration. So there were 4 judges on one side and 1 on the other. After about 20 or 25 years, Justice Bhagwati was interviewed by a newspaper. And do you know what he said? He said, "I made a mistake. I should have joined Justice Khanna." Not only he, but Justice Chandrachud, also in a separate interview, said the same. I don't know why they said it. Was it to ease their conscience or was it for some other reason? But just imagine if these 2 had sided with Justice Khanna, it would have been 3 against the other 2, and this infamous decision would never have existed. Fortunately, this decision has now been overruled in the privacy case 2 or 3 years ago. And there is a small irony in this, that Justice Chandrachud, the senior, the father, was the Chief Justice who gave that infamous judgment. And his son, the junior, Dhananjay Chandrachud, the son, overruled the father's judgment. Then we have the writ of mandamus. In Latin, mandamus means "we command." This writ is issued when a public authority is not doing what he is supposed to do. So the court commands him to do it. Now, I think all of us have gone through this, and a very common practice in government and other offices is just to sit on the file. Your application is not accepted, but it is also not rejected. Because if it is rejected, you may go to court and it may be reversed. So the best thing is just sit on the file, don't take any decision. If this writ is issued, the court orders that officer to take a decision in the matter. Then we have the writ of prohibition. The writ of prohibition is issued by a superior court to an inferior court, saying that you have no jurisdiction to try the case which you are about to try. I feel that this particular writ is based on the famous saying, "Prevention is better than cure." You prevent the court from usurping any jurisdiction which it does not have. The writ of certiorari is the fourth one, where a superior court tells the inferior court that all the proceedings of a particular matter should be sent to the superior court so that the superior court can see if the court is exercising proper jurisdiction. Then you have the writ of quo warranto. Quo warranto in Latin means by what warrant, by what authority. So if a public office is occupied by a person who is not qualified to occupy that office, the writ of quo warranto can be issued, and it has been issued to a chief minister, chairman of a municipality, advocate general, member of the university senate, and even our vice chancellor of the Mumbai University. Now, the Supreme Court has not only entertained what is known as public interest litigation, PIL, but it has also encouraged public interest litigation for the good of the people. And here, one legal rule has been relaxed. This is the rule of what is called locus standi. Locus standi means what right do you have to file this case? So if I entered into a contract to sell my house to you, either you could file a case against me or I could file a case against you, but not a third party. But here, the courts have relaxed this rule. For example, 2 Delhi professors wrote to the Supreme Court about the abnormal conditions in a particular inmate house in Agra. And that letter was treated as a writ petition. So therefore, any interested person can do this. As I just told you, letters sent to the court, telegrams sent to the court, and even one step further, nobody has approached the court, but the court takes cognizance, what is known as suo motu cognizance. That means cognizance on its own, let us say, after reading a report in the newspaper. So this is interesting. Nobody has approached the court, but the court itself says, what is this going on? Let us look into this matter. Now, all of us know that litigation in India is both expensive and protracted. It takes years and years and years to come to a conclusion, and the court fees themselves are sometimes so prohibitive that a common man hesitates to file a suit. In the case of writ petition, it is both cheaper and faster. Cheaper because standard fees are prescribed by the state. I think in Maharashtra, it is 250 rupees, court fees, that's all. Now, how can we say that it is also faster? When protracted litigation, including writ petitions, will definitely take 5 to 7 years, if not more, to come to judgment. And I'll tell you how it is faster. As soon as you file a writ petition, you must also file an application for an interim order of injunction or stay against that particular notification, rule, law, whatever it is. And once you succeed this, if you succeed in this, then the court passes an order giving you relief, and then you have nothing to worry about because this order will be enforced, and therefore, even if the writ petition takes 7 years or 8 years, this order continues. And therefore, you have got what you wanted. And sometimes you get this within less than a week. If I may just give you one example, I will not take too much of your time because I know that other things have to be done after my speech. But I'll just give you one example of the Mumbai University. The Mumbai University suddenly got this brainwave that, now I'm talking of the pre-COVID days, that let there be a normal examination. Students will go and write their papers, but the correction will be online. What do you mean by online? The written papers will be scanned, and then the professor will sit before the computer and give marks to those papers. And each booklet had a barcode. Now, good students need more than one booklet because they have a lot of matter to write. The second booklet which I take will have a different barcode. And therefore, the computer gets confused. And either it gives me marks only for the first booklet or only for the second. And believe me, there were hundreds of cases at the Bombay University. So many of them at GLC itself. Good students were shown as getting 16 and 17 and 18 marks out of 100. What was this? Only their marks in the second subject. And the confusion could not be solved because where is the first supplement or where is the second supplement? Everything is online. Your supplement is lost in cyberspace, if I may say so. And repeated visits to the university at Kalina. They had to go to the storeroom and get out their physical papers, and then justice was done in the matter. I remember one student from JLC was a blind student. The same thing happened to him. He could not go alone to Kalina, and he had to make 7 or 8 trips to Kalina before they found his lost supplement. So the university came up with a very brilliant idea. They said, from the next exam, every student will get only one subject. You have to write within those pages only. Once again, this was not fair. I am not asking for more time. But if I finish my first supplement, why can I not continue on the second supplement? No, you have to finish within one supplement. And naturally, the students were very upset. And I told them that the only remedy available, because exam was just about 4 days away, the only remedy available is to rush to the High Court. And mind you, the High Court immediately quashed the notification. In fact, the High Court recorded all this, that the university is faced with a situation where supplements are lost, and therefore it has come out with this idea of giving only one supplement. Now the order was passed, interim order, stay order was passed by the High Court. Once you have this stay order, if your writ petition is pending for the next 5 years, 7 years, you don't bother. The rule of one supplement has been thrown out. So it is from this angle that writ petitions are very useful. In fact, there is
There is some lag on the side of the speaker. So I request everyone to please wait for a minute till sir joins again and we can hear him again. Thank you.
Somebody may want to suitably advise him telephonically.
Yes, I'm doing it.
Yeah. You need to unmute yourself, sir. Professor, you need to unmute yourself.
Yeah.
Yes, am I audible now?
Yeah.
Can you hear me now, please?
Yes, you are audible. You can
you.
continue, person.
Yeah. So MC Mehta said that there are so many factories surrounding the Taj Mahal in Agra that the white stone has almost become grey or black. And the Supreme Court immediately ordered that all these factories which were polluting the Taj should close down. In another case, he filed a writ petition saying that the waters of the holy river Ganges, the water is being polluted by so many industries around the place, and the court ordered these industries either to be shifted or to be closed down. And believe me, there was a time when Mr. MC Mehta single-handedly handled all these cases. He won all these cases, and there were so many cases of PIL, public interest litigation, which he had filed, that the Supreme Court reserved one day of the week, I think it was Friday, only to hear his cases. Now, as everything else in this world, the concept of public interest litigation can also be misused. And there have been people who have been filing frivolous writ petitions, mostly to gain publicity or to take revenge on a competitor in business or something like that. Now, the courts have been quick to dismiss these kinds of petitions. And I remember that in one case, the court told the petitioner, it imposed very heavy costs on the petitioner, and it reminded him that, look, Mr. PIL stands for public interest litigation, not for private interest litigation. So therefore, frivolous, vexatious petitions are not allowed. Now, before I close, if you will permit me, I would refer to two cases which were decided last week, just last week. One by the Supreme Court and one by the Guwahati High Court. The Supreme Court decision was given on 30th of June, and two lawyers filed a writ petition saying that the families of people who have died from COVID-19 should be given ex gratia payment. Under what law? Under the Disaster Management Act. Now you might wonder how Disaster Management Act is connected to COVID. Well, the government itself has notified COVID to be a national disaster. And Section 12 of that Act says that the authorities are bound to compensate a person or a victim or the family in the case of a disaster. So the petition was filed saying that every family of any person who has died from COVID-19 should be compensated and given an ex gratia payment of 4 lakhs. The Supreme Court said the Supreme Court rejected the plea of the government that we are not bound to pay any compensation. And the Supreme Court said that you must make rules within a particular period for payment of ex gratia compensation. The Supreme Court said we are not going to decide whether it should be 4 lakhs. This is not our function. There is separation of powers in the country, and therefore the judiciary does not have to decide the quantum of compensation. The second point which was raised was that when a COVID patient dies, very often the hospital gives the death certificate, and under the cause of death, they write heart failure, lung failure. The Supreme Court said you can't do that because if you write that, the man will not get compensation. But the Supreme Court also gave an example of a guideline with which personally I do not agree. It said that if a person tests positive for COVID-19 and then he dies within a particular period of say 2 months or 3 months, then the cause of death should be shown as COVID-19 so that the family can get compensation. The second interesting decision which came last week was from the Guwahati High Court, where the Mizoram government issued certain restrictions because of COVID-19. These restrictions were, number one, only vaccinated persons of a family could go out of the house to buy groceries or go to a shop or whatever. All persons in a store or a shop should be vaccinated persons ready to produce the vaccination certificate when required. Drivers and conductors of public transport can only be vaccinated persons. The Guwahati High Court, I would say surprisingly, struck down this notification. And it said that this notification means that all persons should get themselves vaccinated, and we cannot vaccinate a person against his will. And therefore, the fundamental right of an unvaccinated person is affected. The court agreed that there can be reasonable restrictions, but it added that this is not a reasonable restriction. I am almost sure the matter will be taken to the Supreme Court, and possibly the learned judges of the Supreme Court may think differently. So I think that is about all for the day. And I sincerely hope that some of you at least know the Constitution a little better than what you knew it at 4:30 this evening. Thank you very much. And I must say that I was happy and privileged to spend the evening with you. Thank you once again.
Thank you so much, sir, for your instructive insights on Indian Constitution. It really means a lot, sir. I just would like to highlight a point that you made about the no right is absolute in our constitution, at least in India, calling it as a democratic country. Having ability to play music on a loudspeaker throughout the night doesn't give us the right. No right is absolute. I would completely agree with you, sir, on this point. In fact, reasonable restrictions and having certain beneficiary limitations to your act is necessary, even if you are minister or a common man like us. If we call this country as democratic country, everyone should have rights, but there should be definitely certain limitations to access those rights. I would also highlight at the end one of the most salient point made by you, sir, where you said that whenever there has to be a right, there has to be a remedy. Without a remedy, a right is definitely not possible or can't hold accountable. Thank you so much, sir, for your time. And I would request Ribeiro, sir, Adia Ribeiro, sir, to give vote of thanks.
If I may just interrupt for 1 minute, I have a strange feeling that Tanaya's house must be very close to a mosque, because of all things, she picked up the loudspeaker case and she was very happy that you can get relief from the Supreme Court if at midnight you hear those people saying their namaz or whatever. And one more thing is that I'm very sorry that my internet got cut 1 or 2 times, but I think that is something which we all face. In fact, talking about that, if I may just take 1 more minute, the Mumbai University has started conducting online final examinations. And many of our students, I think about 50% of our students from GLC are not from Bombay. They are from other places. And there is panic when the examination starts and suddenly either your internet fails or the electricity goes off and therefore you cannot complete the paper. Yes. Thank you, Tanaya, for all your good words.
Thank you so much, sir. Ribeiro, sir, you may go ahead.
Right. Okay. I think I've said a lot before we started, but now I've just the duty of thanking Professor Pithawalla. It was a very, very interesting talk. It certainly made me much more knowledgeable. I've made a lot of notes about it, and I'm sure that our staffer, Ruchi Bhagat, is going to include all these points, the main points, in her presentation, which she will be sharing with the students from different colleges and different schools who interact with PCGT throughout the year. And this is a very good introduction to our project. And we are more enthused after hearing Professor Pithawalla. And I thank him on behalf of PCGT, of its trustees, the staff members, as well as the students who are always so enthusiastic and who give us the real raison d'etre of existing and working for our goals. Thank you so much, Professor. And I wish we have many more good lectures like this. Especially the students will be greatly benefited if they hear more eminent lawyers and professors like Professor Pithawala. Keep, what is that thing that Munabai, the same thing. I request our Ruchi to please go ahead, march along, because we are very happy that this project has been taken forward. Thank you.
Thank you, Mr. Ribeiro. And one last thing is that I wish your trust all the very best and all success in whatever you undertake.
Thank you so much, sir. I would like to thank all the trustees for unanimously approving this program, and the result is this evening, which we all are experiencing. On this note, I would like to share a small experience because we have Professor Pithawala here. Sir shared with you the incident when answer sheets were lost in Mumbai University. One of the answer sheet was mine, and it was of constitutional law. This same subject, my answer sheet was lost, and we fought a battle for that, and I topped in that paper. I received Venkateswaran prize in law. Pithawala sir gave me that prize, and the journey from being a constitutional topper in Mumbai University to leading this constitutional literacy program, I can just sum all this in one word. It is satisfaction. So I would like to thank all the trustees, Professor Pithawala, and all the hosts and volunteers who helped me in this event. And a small instruction for all the interns and campus ambassadors: you can take a 5 minutes break, and we will start with the demo session after this. Thank you.
Yeah. Ruchi, I told you are going to exempt an old man. Huh?
Yes, sir.
I will attend one of your actual sessions with any other college or something to know
Yes,
how it is being structured. Yeah. Thank
okay,
you.
sir.
But I can't sit for more than, I think, 2 hours already. Yeah.
Yes, sir.
Ruchi, this is Gulam Vanvati. Can you tell me how long, just for my information, because I have another meeting, how long will this be now? What time will you be?
So we'll start in 5 minutes, and it will go for 1 hour.
1 hour?
For 1.5 hours, but I'll minimize.
No, that's okay. That's fine. Don't cut it. If I have to leave, I will leave, but you will excuse me, please. In between.
Yes, sir. Yes, sir.
Yes, I am also going to take a break, but if it is possible, I would like to come back and see how Ruchi is managing the show. And
Yes,
I wish
sir.
all of you all the best. Thank you very much.
Thank you, sir.
Yeah.
I'll try to come back. Let's take a 5-minute break.
Thank you very much. We take a 5-minute break and we'll be delighted to have you back, sir.
Yes, I'll try my best.
To watch your student perform so well.
Exactly.